Hello, I am Arnel L. Tolentino from Criminology 34. So for this video, I will answer the 5 questions indicated here. So the first question is number 1. Question number 1. What are the forms of settlement mandated under the amicable settlement at the barangay level? So first is, what is amicable settlement? It is a deal which comes from consensual agreement of the parties in a negotiation process. There is hereby created in each barangay a body to be known as Lupang Tagapayapa. Hereinafter, referred to a lupang composed of a barangay captain as chairman and not less than 10 or not less than 20 members. To be constituted every 2 years in the following manners. Any suitable person actually residing or working in the barangay, not otherwise expressly disqualified by law, in taking into account consideration of integrity, impartiality, independence of mind, sense of fairness, and reputation of for probability, including education, is attainment, may be appointment member. A notice to constitute the lupon, which shall include the name of proposed member who have expressed their willingness to serve, shall be prepared by the barangay captain within 30 days. After this degree shall have become effective, and thereafter within the first 10 days of January of every other year. Such a notice shall be posted in 3 constitutes. Question number 2. Make a distinction between the function of the OADR and the Lupon Tagapayapa. The Lupon has the following function: exercise administrative supervision over the conciliation panel, meet regularly once a month to provide a forum for exchange of ideas among its members in the public on matters relevant to the amicable settlement of dispute, and to enable parties conciliation, panel members to share with one another their observation and experience in effective speedy resolution of dispute. Question number 3. How does international arbitration differ from domestic arbitration in relation to the rules of the ADR system? Domestic ADR parties enjoy the flexibility and lower cost of mediation in arbitration. Compared to litigation in international dispute, disadvantages are magnified when international parties cross national boundaries. They are the few reliable judicial bodies and adjudicate their dispute. There is also often mistrust toward national court and insecurity on which law, substantive and procedural, to apply. On top of this, challenge, language, cross-cultural, and geographical distance exist. There is also a slip-uphill battle in the enforcement of settled dispute on foreign court and runaway cause in international matter. International arbitration, especially international commercial arbitration (ICC), as well as international mediation (IM), provide ready solution for the above complication, while ICC has a long-standing tradition. Long-standing traditional IM is never and less widespread. This might be somewhat surprised as IM, like ICA, has distinct advantage of saving cost business relationship and retaining control over successful outcome. By provide filing of lawsuit in a foreign court, the foundational requirements of acting in good faith and trust are not necessary. Of course, to bring mediation to fruition, however, where parties see the benefits of this and mobilize sufficient goodwill, IM may be the appropriate method. Question number 4. What are the different instances where the parties to dispute may go directly to the court. Applying the aforementioned law in your question, there are instances when a party may go directly to the court, such as when the accused is under detention, when a person has been deprived of personal liberty, calling for habeas corpus proceeding. Action are coupled with provisional remedies, and when the action may be barred by the statute of limitation. Question number 5. Describe the character of office the service of the lupon member. Character of office and service of lupon member. The member of the lupon shall be deemed public officer and person in authority within the meaning of the revised penal code, while in the performance of their official duties shall be deemed person in authority, shall serve without compensation, whether in public or private employment, shall be deemed to be an official time, and that shall be suffer from any diminution in compensation or allowance from said employment by reason thereof. Section 406 RA 7160.